court is required to after an appeal is made under sub 6, the first thing the court would have had to do, which the court has done, is issue an order directing each affected county, municipal clerk, or board and the commission to transmit immediately all ballots, papers, and records affecting the appeal to the clerk of court, or to impound and secure such ballots. I have entered an order requiring them to impound and secure those ballots. Pursuant to 901 sub 7B, the court will promptly following the filing of an appeal shall hold a scheduling conference for the purpose of adopting procedures that will permit the court to determine the matter as expeditiously as possible. We know we have some time constraints here. We do have, the appeals have been perfected. We're now at the point where we need to set a scheduling order to proceed expeditiously from here. I do have the transmittal letter from Mr. Troupis indicating that given the time limitations inherent, appellants will be prepared to submit their complaint, proposed findings of fact, and conclusions of law, the record evidence, and legal memoranda on Monday, December 7th. Mr. Troupis, is that still accurate?
Yes, it is.
Okay. Then, with respect to all the respondents, would it be possible, well, let's set a time of day on the 7th. What I'm hoping for, I know we have a safe harbor issue. That would be December 8th. Obviously, we're going to go beyond that, but I don't want to go beyond that I want to go on beyond that as little as possible. Could you have those in by noon on Monday, December 7th, Mr. Troupis?
Yes, I can.
Could the various respondents have answers filed by noon on December 8th?
Honor, this is Andrew Jones. Hearing no one else speak, I would request that the deadline for the responses be on Wednesday, which I think would be the 9th. And the reason for that request, Your Honor, is there is simultaneously a federal lawsuit that has been commenced by the president. And there is a briefing schedule that was set earlier this afternoon in that case. And those responsive materials are due, including from my clients, on Tuesday, the 8th. So I would request that the deadline for responses be set rather than Tuesday, on Wednesday, preferably at the close of business.
Anyone else, any other respondent have any comment?
Your Honor, John Devaney on behalf of Joseph Biden and Kamala Harris. And I should preface this, Your Honor, with I intend to submit a Pro Hoc Vice application. I have not done that yet. With Your Honor's permission, I'll still go ahead and speak if that's okay.
Go ahead.
Thank you. Your Honor, we concur that Wednesday would be the better day, in part for the reasons Mr. Jones just identified, because of the pending federal district court lawsuit and the schedule in that case. And in addition, the filings that we'll see on Monday from the Trump counsel will be fairly voluminous, and we would feel more comfortable being able to respond to them fully if we had more than one day. We recognize the need to move this along, but Wednesday, for both of those reasons, is the preferred date from our perspective.
Comment from any other respondent counsel?
Yes, Your Honor, this is counsel for the commission. I would agree that a Wednesday response date is more reasonable than a Tuesday for those same reasons already stated by others. Thank you.
Okay, that appears to be a consensus. The court is required to conduct this hearing as expeditiously as possible. However, we don't want to deprive any litigant from being properly prepared. So I will set the date for responsive pleadings, answers to the complaint no later than 5 p.m. on Wednesday, which would be, what, the 9th? Yeah, the 9th. Then we will schedule the actual hearing let's see, under sub B, at the time and place ordered by the court, the matter shall be summarily heard and determined, and costs shall be taxed as in all other civil actions. Can we do that on Thursday?
Yes.
I'm supposed to get a nod here.
Yes.
Yeah, thumbs up. Okay, we can have the hearing on Thursday, 9 a.m., and again would be by Zoom.
Your Honor, this is Andrew Jones again, and it appears I'm the problem here. But in that same federal district court case, Judge Ludwig, District Court Judge Ludwig, just an hour or so ago, set a hearing in that case for Thursday at 9 a.m. It's a little unclear, I would say, at this point, how long that hearing will go. And certainly it'll be done that day, assuming it occurs. But it's unclear whether evidence will be taken, and if so, how many witnesses. So I can't say how long that hearing will last that day.
Here's the court's concern. The safe harbor aspect, that I think we can deal with, but there's an actual hard deadline, December 14th. And man, I hate to bump up against that.
From my perspective, Your Honor, Friday the 11th would certainly be doable for my clients. I see Mr. Troupas shaking his head.
Yeah. If I may speak, yes, Your Honor, I think I would have a problem with Friday because, it really does run up against some very difficult deadlines here. The recount must take precedent. And I realize I'm not involved in the federal case, and while it is a case brought by the president, it seems to me that the recount must take precedent. It is the single most important aspect of this. So I would plead that we do it at 9 o'clock and that and that perhaps others from Hanson Reynolds could handle the matter.
Mr. Jones, what if we set it on the 10th at 1:30 in the afternoon?
Your Honor, this is a difficult spot for me, given that, I'm responding to both lawsuits. I'm lead counsel for the county in both lawsuits. And, as Mr. Troupas acknowledged, it's President Trump that has brought that second lawsuit in federal court. I'm not in a position where I can change the schedule that Judge Ludwig has set. And as I said, I am not certain as I sit here today how long that hearing will last. And I'm certainly not going to be able to leave the hearing once it starts. And as lead counsel, it puts my clients at a disadvantage for me to have to substitute someone else in for this hearing or for that hearing.
And Your Honor, if I may, this is Attorney Kilpatrick representing the Wisconsin Elections Commission and Chairperson Jacobs. I too have clients that are in this federal lawsuit that is going to take place at 9 a.m. on Thursday. And so Attorney Jones and I are in the same boat on that. It's hard to be two places at once.
Your Honor, John Devaney, and I'll join the chorus. We too will be in court on Thursday in that same lawsuit.
May I suggest perhaps that it's scheduled for 1:30 on Thursday, subject to it being postponed to Friday morning then, so that we can do it on Thursday. If we are able, for example, if that hearing were to end rather abruptly, or even within an hour or two or three, we can continue with this. And I'm not trying to put council, they all know that I'm not trying to put people in a tough spot. I'm in a tough spot in terms of deadlines. So if we can do that at 1:30, but if not available, then if your honor wishes, then it could go to the 9 a.m. the following day.
Is everyone agreeable with that resolution? Schedule it for Thursday at 1:30. If, however, the federal action is still pending, the hearing is still going on, that we can then just simply reschedule it to 9 on the 11th. But that's the absolute deadline because the 14th is when the electors meet.
Correct.
I mean, obviously, if the hearing does not occur on, I keep looking over to see the dates on the calendar. If the hearing in the federal matter does not occur on the 10th, or as Mr. Troupas says, it's a very abrupt or truncated hearing, then that Thursday afternoon will work. But I won't be in a position to know until at some point as things proceed on that Thursday morning, whether it really has turned into an extended hearing or whether it opens and closes in the matter of a few minutes. So logistically, I will not be in a good position to let the court know whether Thursday afternoon is going to work or not. I will, of course, defer to the court. And if the court's preference is to set it for Thursday afternoon, I will be there unless I'm in federal court here in Milwaukee. But from my perspective, for a number of reasons, it may be easier for all involved if we just set this hearing before Your Honor on Friday morning. But again, I say that with all due respect to the court, and I will obviously defer to the court's wishes.
Well, our back would be absolutely against the wall at that point. My preference would be to schedule it for the 10th, Thursday afternoon at 1:30, with the understanding that if the federal court action, the hearing is still going on in the afternoon, that it will then be, the court could notify the parties that it would be rescheduled for 9 o'clock Friday morning, the 11th. And hearing no vigorous objection from that, that's what the court will do. I just don't want to be put in a situation where it's the absolute last moment to get it done. And then if there are any glitches, we have no recourse. So let's set the hearing itself for 1:30 on Thursday, December 10th. Again, with appearances being by Zoom. So, Mr. Troupas will have the complaints in by Monday, the 7th. All answers will be in by Wednesday, the 9th. The hearing will be tentatively set for 1:30 on the 10th, subject to change pending on the federal litigation. If it is bumped, it would go to 9 a.m. on the 11th. Now, need we address anything else with regard to scheduling?
Your Honor, John Devaney with one in the weeds question. I think you had originally said that that the Trump Council would submit their materials at noon on Monday. Is that still the operative time, or is it close of business?
Yeah, he wanted to close a business, I think, by noon.
That'll be.
By noon.
Thank you, Your Honor.
And then Wednesday by noon, all answers. Okay?
And Your Honor, we have one other matter required by statute, which is the surety amount.
Yeah, that's been filed and I think it's already been taken care of.
Okay.
I believe, clerk, that's already in there, right? Yes, it's already been complied with.
Thank you.
Any other loose ends?
Your Honor, this is Attorney Kilpatrick again. I'm just wondering if you could explain what the kind of content of the hearing is going to be, so the parties have an idea regarding preparation.
Let me see. According to sub 8 of 901, the court shall separately treat disputed issues of procedure, interpretations of law, and findings of fact. The court may not receive evidence not offered to the Board of Canvassers or the Commission chairperson or the chairperson's designee, except for evidence that was unavailable to a party exercising due diligence at the time of the recount. According to sub 7B, at the time and place ordered by the court, the matter shall be summarily heard and determined, and costs will be taxed as in any other civil action. So my perception is it will be a rather perfunctory hearing where the parties will submit all their documentation. There'll be an opportunity for oral argument, and the court will rule. And the court intends to rule orally from the bench, unless there is something that comes up that does not allow that to occur. Mr. Kilpatrick, anything else?
No, thank you, Your Honor.
Any other comments before we disconnect? I just want to, one time, gentlemen, hold on. I want to verify that the dates given, I'm advised by the Chief Judge of Milwaukee County that we will have the appropriate facilities, a courtroom and Zoom facilities to be able to conduct the hearing on the time frame the court just established. So we're all set. Now, I was going to try to expedite it more quickly by having things filed over the weekend. I'm advised that we cannot accept any filing on the weekend, so at noon on Monday, Mr. Troupas will expect appellant's documentation.
Yes.
Okay, we're all set. Then
Thank-
I will conclude the hearing.
Thank you.
Thank you very much.